Good morning. Product safety law in the UK is about to change. There is no doubt about that. The only real questions are how big will those changes be and what will the impact be on regulators, businesses and consumers alike. I'm Crowe KC and I'm joined by Robin Kingham. We're both barristers at Gough Square Chambers, and between us we spend a significant amount of our time advising on and litigating about regulatory enforcement, particularly where public law, consumer protection and business regulation intersect. This morning we will be looking at the direction of travel in product safety regulation, and in particular at the current set of government consultations that are intended to reshape the regime fundamentally. Our focus is twofold. First, we will look at what is being proposed substantively, how the scope of product safety law is expanding, how responsibilities across the supply chain are being recast, and how concepts like digital functionality, AI and online marketplaces are being brought more squarely within the regulatory framework. Second, and this is where Robin will spend a fair bit of time, we will look at enforcement, the move towards consolidated enforcement powers, the proposed introduction of civil monetary penalties, and what that means in practice for regulators on the one hand and businesses on the other. We are, however, very conscious that the audience includes regulators, trading standards professionals, solicitors and in-house lawyers, so our aim isn't to advocate any single perspective, but to try to flag the points where the proposals raise practical or legal issues that are likely to matter on all sides, how these powers will be exercised, how they might be challenged, and how risk is likely to be perceived and managed once the new regime is in place. With that in mind, Robin will start by setting out the landscape of the current consultations and the broader reform programme before we move on to some of the more difficult questions they raise. Robin.
Thanks, Cameron. I'll start by setting the scene of what's going on at the moment. On the 31st of March this year, the OPSS and the Department for Business and Trade published a package of 3 linked consultations as part of this major overhaul of the product safety regime. All 3 consultations are currently live, and all 3 will close on the 23rd of June, which means that there's still time for people to engage with the process if they want to. Each of these consultations is intended to lead to secondary legislation made using the powers in the Product Regulation and Metrology Act 2025. So in other words, we aren't looking at another round of primary legislation going through Parliament, but at regulations that can be made relatively quickly once the policy decisions are settled. The first consultation is on the new product safety framework. This is concerned with what the core product safety rules should be, replacing the General Product Safety Regulations 2005. It addresses which products are within the scope, how product safety should be assessed in modern and digital markets, and who in the supply chain should owe legal duties. Running alongside that is the second consultation on market surveillance and enforcement. This looks at consolidating existing enforcement powers, clarifying how regulators monitor products once they're on the market, and most notably, introducing civil monetary penalties as an alternative to criminal prosecution. In practice, this enforcement consultation is just as significant as the substantive framework because it's going to change the risk exposure for businesses operating in this space quite a bit. The third consultation is narrower, and that's the review of fire safety requirements for domestic upholstered furniture. It's not really relevant to this talk, but I mention it just for completeness. There's one final point that's worth flagging on before I move on, and that's that this consultation process is a real opportunity for anyone with an interest in this area to influence a number of things, including how wide the new duties are drawn, and in particular, what procedural safeguards sit around the proposed enforcement powers, specifically civil monetary penalties. So if you know anyone who's interested in responding to the consultation, then I think it's worth encouraging them to respond. And of course, we at Gough Square are always happy to help with that if needed. With that context in mind, Cameron will now explain what's being proposed in the new product safety framework itself before I come back in to discuss enforcement and civil sanctions.
Thanks, Robin. The headline change is the creation of a single modernised core product safety framework that applies to almost all products. Under the current GPSR, regulation is limited to consumer products. Products intended for workplace or business use often fall outside the regime unless captured by sector-specific regulation. Well, under the new proposed framework, that distinction largely disappears. Consumer products and business use products are both intended to fall within scope, whether sold online or offline, and whether purely physical or digitally enabled. There are still exclusions which broadly track existing arrangements: food, medicines, medical devices, aircraft, military equipment and animals remain outside scope, but the default position has changed, or may. Instead of asking whether a product is a consumer product, the framework starts from the assumption that products are regulated unless they're explicitly carved out. That represents a significant shift away from the GPSR and removes some of the grey areas we have had to work around for years when products sit uncomfortably between consumer and professional use. Turning to what counts as a safe product, the consultation doesn't propose to fundamentally rewrite the definition. The familiar GPSR concept is retained. A product is safe if, under normal or reasonably foreseeable conditions of use, it presents no risk or only the minimum acceptable risk. What does change is how safety must be assessed in practice. Under the GPSR, assessment focuses on a few relatively limited factors, such as a product's physical characteristics, how it's presented, and the needs of vulnerable consumers such as children. Under the new framework, regulators will be directed to consider a much wider range of factors. These include machine learning functionality, cybersecurity vulnerabilities that may lead to physical harm, and whether products might be mistaken for food or otherwise appeal to children, even if not intended for them. The consultation also flags gender and disability-related safety impacts as relevant considerations. I think there's also a fairly fundamental shift being proposed here. Safety isn't going to be treated as something that can be assessed once, at the point a product is placed on the market. It's treated as dynamic, capable of changing over time through software updates, connectivity and modification. That's a marked departure from how GPSR compliance has traditionally been approached. A simple way of illustrating this is to think about a self-driving car. At the point it's first placed on the market, the hardware and software work as intended and the vehicle is safe under normal conditions of use, you would hope. On any traditional static analysis, that would be the end of the compliance question. But imagine that months or years later, the manufacturer releases a software update designed to improve navigation or efficiency, and that update contains a defect which causes vehicles to misinterpret road markings and, in some cases, drive off the road. On the consultations approach, product safety is no longer frozen at the moment that the product is placed on the market. The same product can move from being compliant to being unsafe over time, without anything about the physical object itself having changed. The framework also reflects a broader shift in how safety outcomes are achieved. Where possible, the government proposes to move away from detailed product-specific rules and towards risk-based obligations supported by standards. The current designation mechanism for standards will be retained and expanded, and compliance with a designated standard continues to create a presumption of safety, though not immunity, of course, from enforcement. What is new, however, is the emphasis on faster designation, including the use of PAS documents to respond quickly to emerging risks, such as those associated with e-bike batteries. Another major change is to the proposed division of responsibility across the supply chain. The framework introduces 3 categories of regulated person: producers, onward suppliers, and online marketplaces. Producers broadly correspond to manufacturers and importers under the GPSR, but with important clarifications. Overseas sellers can be treated as producers for UK sales, and digital modification of products can itself create producer responsibility. Returning to the self-driving car example, this helps explain what digital modification means in practice. If the original manufacturer places the vehicle on the market in a safe state, but a later software update materially alters how the car behaves on the road, that act of digital modification could itself amount to putting a new or newly modified product on the market. Responsibility doesn't simply sit forever with the original physical manufacturer. It can attach to the entity that designs or controls the software change that gives rise to the risk. Turning then to onward suppliers. Onward suppliers replace the GPSR category of distributors and are defined more broadly. They expressly include fulfillment service providers, as well as logistics and warehousing businesses. Their duty is framed around due care, checking for recalls, understanding common hazards, and not supplying products they know or ought to know are unsafe. This brings fulfillment houses into scope and closes a long-running gap in GPSR enforcement. Finally, there are online marketplaces. This is something which has generated a lot of discussion recently. For the first time, online marketplaces will be explicitly defined and regulated as a distinct category of regulated person. The definition is likely to be broad, capturing traditional marketplaces such as Amazon and eBay, social commerce platforms like TikTok Shop, and, it would seem, any online service that facilitates third-party sales to UK consumers, regardless of whether the platform owns the goods, handles payments, or fulfills the order. Perhaps the most important shift is that online marketplaces will be expected to act proactively rather than reactively. The proposed duty is to exercise due care to prevent, identify, and remove dangerous products. The consultation gives concrete examples of what this might involve. Risk-based monitoring of listings, checks against recall databases, and systems to prevent known dangerous products from being listed in the first place. This goes well beyond the distributor duties envisaged by the GPSR. That is the substantive framework. Sitting behind it and giving it much of its practical force are, of course, the proposed enforcement reforms, which Robin will tell us about now.
Thank you, Cameron. On enforcement reform, the central proposal is the creation of a consolidated enforcement toolkit. And before I turn to civil monetary penalties, I should flag that the consultation is also proposing a clearer and more structured enforcement ladder, and that includes the use of compliance notices and enforcement undertakings. These aren't novel concepts, but they've been used inconsistently in the product safety context to date, so it's good to see them highlighted in the consultation. It's also worth emphasising, of course, that criminal enforcement isn't going away, and I'd anticipate that prosecutions will still be brought where there are deliberate breaches of the law. So, for example, where a business makes a conscious decision that it's more profitable to break the law than it is to comply with it. But the most striking element of that toolkit is the proposal to introduce civil monetary penalties for breaches of product safety law. One useful comparator here is the Competition and Market Authority's new powers under the Digital Markets Competition and Consumers Act 2024, known as the DMCCA. As many will know, the DMCCA now allows the CMA to impose civil penalties of up to 10% of global turnover for breaches of consumer law without needing to go anywhere near the criminal courts. And that's a very significant shift to the way that enforcement works. And it's one that's radically changed the risk profile for businesses already. We're already seeing the practical consequences of the change. So, for example, I'm currently acting in a case which involves a very large company. If you imagine that the company has a turnover of, say, between 5 and 8 billion pounds, then it ultimately could result in a potential exposure to a fine in the order of between 500 and 800 million pounds for a breach of consumer law under the CMA's civil enforcement powers. That gives you a sense of the stakes that are involved once enforcement shifts from criminal prosecution to turnover-based civil monetary penalties. And this isn't theoretical or down the line. The CMA has already begun exercising these powers in earnest. Earlier this month, it issued its first civil fines under the new regime, over £4 million imposed on the AA and BSN driving schools. that marks a clear signal that direct enforcement isn't just a possibility, but very much an active and growing part of the regulatory landscape. Another important feature of this model is that it doesn't involve the courts at all. The regulator investigates, determines liability, and then imposes the penalty itself. The only role for the courts is on appeal after the decision's been made. And that's really a profound change from the traditional product safety enforcement model, which has mainly relied on criminal prosecution with all of the procedural safeguards that brings with it. I think it's fair to say that this has already raised some very difficult and novel questions about the relationship between regulators' investigatory powers and the rights of those that they regulate. In the CMA context, we're seeing challenges that go directly to the scope of, for example, information gathering powers and the extent to which businesses can be compelled to provide material that may later be used against them in imposing a civil monetary penalty. In particular, there's a real question as to whether it's compatible with the privilege against self-incrimination and whether these powers are compatible with Article 6 of the European Convention on Human Rights and the right to a fair trial. All of this is very much an evolving and contested area of practice, and what I find striking, I suppose, from a product safety perspective is that the current consultation doesn't yet engage with these sorts of issues, despite potentially proposing a similar enforcement model to that used by the CMA. If the OPSS is granted the power to impose significant civil monetary penalties without court oversight, I think it's inevitable that we're going to see similar challenges arise in the product safety sphere, particularly from large businesses facing very substantial financial exposure. So it's a difficult and emerging area of practice, and the product safety consultation leaves a number of questions very open. In particular, I think there are three major unanswered questions relating to these civil penalties. First, of course, the scale of the civil penalties isn't yet settled. The government hasn't decided whether to use fixed penalties or whether they might be variable depending on the nature of the breach, or whether they'll be calculated by reference to turnover in the same way as CMA consumer law penalties. This is a really critical point because a turnover-based model would align product safety enforcement with other areas of consumer law, but it would dramatically raise financial exposure, particularly for large or multinational businesses. Ultimately, I think the government's likely to look to the CMA's consumer law powers, even though, of course, no decision has been made yet. Secondly, the consultation doesn't yet specify the way in which these fines might be appealed, which court or tribunal they'd go to, or what the standard of review on appeal would be. Will it be a quasi-judicial review of the regulator's decision-making process? Will it be a full rehearing on the merits? Or will it be something in between? CMA penalties are appealed to the King's Bench Division of the High Court and are subject to something of a hybrid approach where the court can hear evidence and make its own findings of fact, but where it has to be satisfied that CMA's decision was wrong. In the financial services context, appeals go to the upper tribunal, and the rules are somewhat complex about whether it's a full rehearing or a review of the FCA's decision, depending on what's happened in the case. But I think these are all really important points and the sort of thing that should be flagged in responses to the consultation. Third, there's a real uncertainty about who will be able to use these powers. The consultation, at least so far as I could see, doesn't clearly state anywhere whether these civil monetary penalties will be available only to the OPSS or whether they'll also be exercisable by local authority trading standards departments. And that distinction, of course, matters. Trading standards services remain the frontline enforcers for most product categories, but of course they are fragmented and unevenly resourced. We see this in unfair commercial practices cases where the CMA has these new powers to impose civil penalties, but trading standards don't. The result is that unfair commercial practices are being charged as criminal offences by local authorities, but being handled by the CMA as civil enforcement cases, which perhaps can seem a bit inconsistent and unfair if you're a business dealing with multiple regulators at the same time. So there are a number of unanswered questions which will hopefully begin to take shape over the coming months. But regardless of what ends up happening, I think the net result is going to mean greater regulatory risk for businesses, not just the possibility, of course, being on the hook for enormous fines, but also that a wider range of businesses are going to be saddled with new regulatory obligations.
So to bring this to a close, what the consultations make clear is that product safety regulation is moving towards a much more expansive and interventionist model, both in terms of who's regulated and the tools available to regulators. That brings obvious opportunities, but also legal and practical challenges that will need to be worked through carefully. The consultation period is a real opportunity to shape how those powers are framed and, just as importantly, how they are constrained and exercised in practice. Well, we hope that we've said today stuff that has helped identify some of the issues that may be worth focusing on from wherever you sit. Thank you very much for turning up and tuning in to Gough Square Live, and please do feel free to email through any questions you might have for us about the topics from today or indeed anything else. The next episode will be in June. I'm afraid I don't know what it's on. Do you know what it's on?
I don't yet. It's a surprise.
Okay, it's a surprise. You'll have to tune in for what will be, no doubt, a mysterious, surprising, yet insightful episode from someone from Chambers. But until then, it's goodbye.
Goodbye.